law. So I'm talking about attorney's fees, right? So people hear attorneys in family law talk about an award of attorney's fees all the time in the sense of like, is there a need and ability to pay? I talk about that on here all the time, that's what we have to figure out. If you're gonna get attorney's fees, you have to have a need and the other person has to have an ability to pay. And if you have a need and they have an ability to pay, then are you going to get your attorney's fees awarded? Probably. Now, but there's not like a strict certain rule in Florida that says if there's a need and an ability to pay, 100% of your attorney's fees are covered. That's not the way that it works. And because it's not the way that it works, most family law attorneys are not going to sign up to take, and when I say most, I mean like 95% of family law attorneys are not going to take a case without having some kind of payment from you up front. So what that leads to is a lot of people thinking that because there is such a thing as attorney's fees in family law cases, that means that you can hire me or hire an attorney and the other person just pays my fees. That almost never happens unless I'm doing like an uncontested or a collaborative case. It is very, very, very rare that the other party volunteers up front to pay my fees, or the alternative would be that I would take the case without getting any kind of payment at all, and I would do all the things that I have to do to get an award of attorney's fees, which means I have to file responsive pleadings, I have to engage in mandatory disclosure, I have to file a motion, I have to prepare for that motion, I have to schedule and set a hearing, I have to show up at the hearing, I have to have a full evidentiary hearing that dives into everybody's finances, income, expenses, all of those things. It's a lot of work. It's not like a little bit of work to have a hearing on attorney's fees. So if I can't voluntarily get the person to pay me, then somebody is going to have to pay for me to do all of that work to get there, or I'm going to have to say I'm willing to do all of that work for free in hopes that I'm going to get paid on the back end. And I don't know very many people who do that in life, who say like, sure, I'll go do all the work and hopefully I'll get paid for it. So that's why family law attorneys don't usually take cases up front without any kind of payment and just hope we get an order that awards attorney's fees on the back end. The way that it typically works is that you are going to pay the attorney, and then the attorney is going to do work, and part of that work is going to be filing a motion and having a hearing on attorney's fees. If you then get a judgment, an order that says that you're entitled to attorney's fees, then either those fees can pay you back for what you paid me, or if there's a lot more for me to do and we didn't get, and let me say this too, because I may be confusing people. So there's also two different kinds of attorney's fees, right? I can ask for attorney's fees that have already been incurred to be reimbursed, and I can ask for attorney's fees to move forward in a case for prospective fees so that I have the ability to do work moving forward. So first we have to take into consideration which kind of fees we got, and then the second thing we have to take into consideration is how much work is there to be done and how much did you get. So it's kind of an ongoing conversation, but there is just not this like clear cut and dry thing in Florida family law where just because you are the lesser earning party, you automatically are going to get your fees paid. And it also is not this kind of thing that I think people sometimes think in their brain, that if you have a need and the other person has an ability to pay, that like poof, there's an order and they pay your fees. It doesn't work that way. There's no like absolute guarantee or absolute obligation in family law. So 99.9% of the time, you are going to pay something to an attorney up front in order to represent you, even if you're going to seek fees from the other person. So what a lot of law firms do, which my office does sometimes do, depending on the case, is we sometimes will take a lesser fee up front, like a smaller amount of money, to give us enough money to cover anything that has to be done right now, and then filing the motion for fees and having a hearing on the motion for fees. Sometimes we'll take a small amount of money to get us that far and not ask for so much up front if we think there's a really good chance we're going to get attorney's fees from the other side. But even then, you're still talking about some amount of money up front. And, you know, if there are attorneys out there who are more frequently than I am aware of taking family law cases without any money up front, I'd be interested to know who they are or what they're doing and chat with them about it, because I know a whole lot of lawyers and I don't know any lawyer that practices family law in Florida that takes cases without some kind of payment up front, unless you're doing a pro bono case, which is a very different situation. So anyway, that was my rant about attorney's fees. I hope that that makes sense to people, because I feel like people really show up very confused about this attorney's fee issue.